Twisted Case.
New here? If careful, fact-checked crime storytelling is your thing, hit subscribe. Two men are shot inside a Toronto home. Police say the shooter is just 14. Was this a random attack, or something planned? You're about to see what the official record says, what the charges suggest, and what a rare court order forced the city to confront. All accused are presumed innocent. Around 5:10 p.m. It's late summer. The sun is still high, the air is warm, and Eglinton East is busy. Buses, construction zones, and apartment blocks. Officers respond to a shooting call at a residence near Danforth Road and Eglinton Avenue East. Two men, 21 and 22, are hit. They're rushed to hospital. Police say the injuries are serious but not life-threatening. We're going to explain what Toronto police put on paper, what that means for the people involved, and why a judge briefly let the public see a young person's identity, then ordered everyone to put that genie back in the bottle. The goal: understand the facts, the law, and the stakes for a neighborhood that didn't ask for any of it. Two men in their early 20s survive. That matters more than anything else. Surviving doesn't mean fine. It means hospital intake, imaging, pain management, and a long set of appointments most people never see. It means a family group chat that switches from jokes to logistics, rides, time off work, who brings meals, who sits overnight. We won't name the victims here. We keep their privacy intact and center their recovery, a choice consistent with ethical reporting in cases where the victims haven't chosen public attention. If you want documentary stories that keep the facts straight and the tone respectful, subscribe and share this with someone who cares about both safety and fairness. Here is the official outline from Toronto Police Service, TPS. A young person goes to a residence near Danforth Road and Eglinton Avenue East. The young person has a firearm. The firearm is discharged. Two men are struck. The young person flees. Both victims, 21 and 22, are taken to hospital with serious, non-life-threatening injuries. This language is careful, because it has to be. It's the allegation, not the verdict. It sets the scene without guessing at motive. It avoids the word random. It avoids targeted. It states what can be said while an investigation is still moving. Days later, investigators take a rare step. They obtain a court order under Section 110 of the Youth Criminal Justice Act, YCJA. That order lets them do something they usually can't do with a young person: release a name and a photo to help find the suspect. It's time-limited and very specific. When the arrest happens, or when the order expires, publication must stop, and the image must come down. TPS states that plainly. The YCJA normally protects the identity of young persons. This clause is the exception. It's about quick arrest and public safety. It's not a permanent reveal. After the arrest, TPS lists the charges sought against a 14-year-old youth. Read them as allegations, not conclusions. 2 counts of attempt murder. 2 counts of discharge firearm with intent. Unauthorized possession of a firearm. Possession of a firearm knowing possession is unauthorized. Unauthorized possession of a firearm in a motor vehicle. Possession of a loaded, prohibited, or restricted firearm. Disguise with intent. 2 counts of fail to comply with release order. In plain words, the charge sheet alleges a gun present and fired, concealment of identity, a vehicle connected to possession, and breaches of earlier court-ordered conditions. We'll unpack why those details matter. A short time later, TPS updates the same case page. The youth has been arrested. Once that happens, the legal rule flips back. The name and photo can no longer be published and must be removed from everywhere. That includes social posts. Reputable outlets follow that rule. Individuals often don't. But the law is clear. A 14-year-old. That number is the headline most people never get past. When a suspect is this young, the public conversation splits quickly: safety and speed. People argue the public needs the name and photo to help make an arrest and prevent more harm. Others argue a child's identity should not be blasted out, even briefly, because the internet never forgets. A face posted for 2 days can follow someone for life, no matter the outcome in court. The judge's order tried to split the difference, authorize identification for apprehension, then shut it off after arrest. It's a scalpel, not a sledgehammer. Whether the internet honors the scalpel is another question.
Step 1. Official Story.
Location and time. 2 victims injured. Suspect later arrested. Charges listed. Step 2. What the paperwork implies. That suggests the face was covered or appearance altered. Unauthorized possession in a motor vehicle. A vehicle is in the mix, raising possibilities: arrival, getaway, or storage. Fail to comply, twice. That hints at earlier conditions from a prior matter, conditions the Crown says were breached. These points are not the whole story. They are signposts from the charge list. They indicate planning, concealment, and prior court contact, if proven. If a court had already set conditions, how did a gun and a doorbell still meet inside a home? That's the uncomfortable question people in the neighborhood are left asking. Identification leaves the folder and enters the city. Not forever, just long enough, the court hopes, to help locate a suspect. Then the update: arrest made. Publication ends. Remove the image. We climb in clear, numbered beats. Each adds new information or stakes. No file. 1. The neighborhood breathes differently. For a short window, anyone who looks young and tall near Eglinton and Danforth gets second glances. Parents hold their kids closer at crosswalks. Teenagers feel watched. Life continues. Buses sigh. A corner store doorbell beeps when it opens. But the temperature of attention changes. This is the predictable social effect of a time-boxed public manhunt. It isn't about guilt, it's about how identification changes behavior. 2. The charge sheet's verbs matter. Charges are allegations, but they are specific. Discharge with intent is not reckless discharge. Disguise signals concealment. Loaded, restricted raises the risk category. Motor vehicle points to mobility. If proven, these suggest preparation, not a spontaneous explosion. If disproven, they show how much the Crown thought it could prove. Either way, the verbs tell you the theory of the case. 3. The victim's timeline stretches. Serious but non-life-threatening is a medical classification. It does not predict recovery. There's pain, sleep problems, physiotherapy, and in many cases a fear response when doors open or loud sounds pop. This is where support networks matter: family, employers, and counselors. We keep their names out of this and respect their privacy. 4. The internet versus the order. The YCJA order is clear: after arrest, stop publishing and remove the identity. Newsrooms comply. Personal accounts are another story. Screenshots float. Old posts get shared by people who missed the update. That disconnect is not a legal debate, it's a practical one. The law speaks narrowly. Platforms echo broadly. The result is a permanent tension between youth privacy and virality. 5. The investigative grind. Behind the press release is the slow work: canvassing cameras along Eglinton East, analyzing phone records if warrants exist, knocking on doors, tracking any vehicle reference in the charge list, and tying a person to a place and a time with corroboration. None of that moves at the speed of a tweet. It moves at the speed of paperwork, which is slower but sticks. 6. The red herring that didn't hold. Early online chatter labeled the shooting random. The official releases didn't use that word. They didn't say targeted either. They stayed disciplined. That's not vagueness, that's accuracy under uncertainty. Rumor filled the gap. Then the arrest clarified the public posture. Let the courts decide motive, not comment threads. 7. The double life question. Adults like neat categories: good kid or bad kid. Real life rarely obeys. A young person can do well at school and still make a catastrophic choice on a Sunday. If the fail to comply counts connect to an earlier release order, it means there was already court involvement. The system had touched this youth once. That doesn't assign blame. It raises the policy question we'll close on. How should responses calibrate when the person is 14? 8. The arrest flips the script. Once the arrest happens, the case transitions from community search to court process. The identity shield goes back up. Commenters are supposed to take the name down. Responsible channels do. The rest of the path, disclosure, elections, judge or jury, resolution, belongs to the justice system now. After days of canvassing, reviewing video, and building the trail that links a face to a place and a time while the court-ordered photo circulates in the public square, investigators make their move and take a 14-year-old into custody on a list of firearm-related and attempt murder charges tied to a double shooting inside a residence. The update posts, arrested. Identity publication must stop. What's known and sourced. Where and when, Danforth Road and Eglinton Avenue. August 31st, 5:10 p.m. What happened? Alleged shooting inside a residence. 2 men injured, serious but non-life-threatening. Suspect fled. Legal steps. Court authorized youth identification under YCJA S.110 to aid arrest. Name/photo released temporarily. Outcome: youth arrested. Charges listed. Identity publication now prohibited and removals required. What remains to be proven? Motive, the role of any vehicle, the exact sequence at the door, and the strength of the evidence behind each charge. That will be for a court, not for us. This case puts 2 values in a collision course. 1. Community safety and speed. Quick arrests can prevent further harm. Public identification can help. 2. Youth privacy and rehabilitation.
Adolescents changent fast.
Public branding sticks even faster. The judge tried to balance these by allowing identification only to catch the suspect, then immediately resealing identity. That's the law moving with a scalpel. The open question is how well that works in a world where screenshots don't expire. Straight timeline. August 31st, 5:10 p.m. shooting call near Danforth Road and Eglinton Avenue E. 2 men, 21, 22 injured. Serious but non-life-threatening. September 4th. Police obtain court authorization under YCJA S.110. Name/photo of young person released temporarily to aid arrest. Publication of youth's name/photo now prohibited. Removal requested from all platforms. Charges listed: attempt murder ×2, discharge firearm with intent ×2, several firearm possession counts, disguise with intent, and 2 failures to comply. Major outlets reported the wanted notice and then the arrest update, for transparency, not speculation. This case revolves around thresholds. The door opens. Shots are fired. A station door. Investigators bring a 14-year-old into custody. A digital door. A photo enters public feeds, then is supposed to leave. If you remember nothing else, remember this. The law says young people get privacy, with rare exceptions to protect the public and speed an arrest. This case used that exception, and then closed it on arrest, exactly as designed. Whether that works in practice is the part we collectively control by what we post, share, and delete. YCJA equals Youth Criminal Justice Act, Canada's law for people 12 to 17 in conflict with the law. Default: don't publish a young person's identity. Exception: S.110 a judge can allow temporary publication to help find the youth. After arrest or expiry, the exception ends. Take it down. That's what TPS reminded everyone to do. What we don't do. We don't guess about motive. We don't show or say the youth's name now that an arrest has happened. We don't dramatize pain. We don't rush to judgment. We do center the victims, respect the accused rights, and keep the record accurate. Was this random? The official releases don't say random or targeted. They stick to verifiable details. A youth went to a residence. A firearm was present and discharged. 2 men were injured. The youth fled. We don't label motive we can't support. Why was the name ever released? A judge allowed it under YCJA S.110 to help find the suspect quickly. After the arrest, the name/photo must not be published and should be removed. What's next for the case? Standard process: disclosure, court dates, and a decision on resolution or trial. The charges are allegations. The burden is on the Crown to prove them. Can outlets, or creators, still show the photo now? No. After arrest, publication is prohibited. TPS specifically asked for removal from all platforms. 2 men start the slow work of recovery. A family learns hospital routines. Another family learns court routines. A neighborhood learns how quickly a doorbell can change a day. The accused is 14, still a kid, legally and neurologically, even if the allegations are grave. That's why Canada built the YCJA. Accountability plus a shot at rehabilitation appropriate to age. That does not erase harm done. It aims to avoid creating a lifelong headline out of an adolescent who may still be reachable. We can hold 2 ideas at once. 1. People harmed deserve care, respect, and safety. 2. Young people who do harm still deserve a system designed for their age. Those ideas feel like they collide. The law is the space where we try to make them fit together. Verified Core Facts, TPS. Time and place, August 31st, 5:10 p.m., Danforth Road and Eglinton Avenue E. Allegation: youth attended a residence. Firearm discharged. 2 men, 21-22 injured. Suspect fled. Legal step: court authorized short-term identification under YCJA S.110 to aid arrest. Outcome: youth arrested. Publication of identity prohibited. Charges listed: attempt murder ×2, discharge firearm with intent ×2, several firearm possession counts, disguise with intent, 2 failures to comply. Global News, Canadian Press, via Yahoo/Winnipeg Free Press, and others reported the police request and the subsequent arrest update. Your turn, no shouting, real reasons only. When a suspect is only 14, should courts use temporary public identification to speed an arrest even though the internet never forgets? Or should youth privacy be protected absolutely, even if it slows the case? Tell me where you land and why. Are we balancing safety and rehabilitation well here, or not even close? Twisted Case. If you want more clear, humane breakdowns like this, subscribe. We'll keep the facts tight, the pacing clean, and the people at the center.